Hello, thanks everyone for joining this session on navigating the family law courts. My name is Emma. I am the Family and Domestic Violence Solicitor at the Mid North Coast Community Legal Centre. So I'm a family lawyer, worked as a lawyer for victims of domestic violence in their family law matters for about 10 years at roles at Women's Legal Service and Victoria Legal Aid, as well as at the Mid North Coast Community Legal Centre. So the Mid North Coast Community Legal Centre provides free legal advice for those that can't afford a lawyer in our area, so from Coffs Harbour to Taree. The centre's been operating out of Port Macquarie for about 10 years and more recently opening an office in Coffs Harbour. So we focus mostly on civil law problems. People experiencing family and domestic violence experience on average around 20 different legal problems each year. And that's in contrast to about 2 for the general community. And those legal problems can range from issues with family law and AVO matters, issues with employment, discrimination, debts, infringements, consumer law, tenancy, Centrelink issues, so just a whole range of different legal issues. So my role really complements those civil law services that are offered by the centre, in that I primarily offer family law services for victims of domestic violence. And the family law system can be an extremely daunting place for anyone, and in particular those experiencing domestic violence. So the family law system has made some significant steps forward in addressing safety concerns for those experiencing family violence, including things like the ban on direct cross-examination of victims of family violence in family law matters. There's still, of course, room for improvement when it comes to the way that the family law system deals with domestic violence. So I've written and spoken pretty extensively about the changes that I'd like to see in previous roles in relation to improvements for safety for parents and children in the family law system. But today we're really going to focus on how you can best support your client when navigating through the family law system, and some kind of practical elements and tips. Okay, so today, as I said, hoping to just give you an overview of the family law process, including some of the new changes to the family law system that some of you might have heard about, to help you better support your clients. We're going to break our session today into kind of 3 main sections. So things that we're thinking about when, before and right at separation, things that might be most relevant when trying to reach an agreement, so during that phase. And then also what to expect at court. So if the matter does end up in litigation in the family law system, what are some kind of things to expect in terms of stages of a matter, the different professionals involved, and some kind of terms you might have heard, and some knowledge around that. Okay, so this presentation is not and should not be taken to be legal advice. As you all know, experience of domestic violence and family law are all completely different. They're rapidly changing. So the way that the law applies to one client may be really different depending on the circumstances of another client. So really important to get individual legal advice. And so if you have a client who's experiencing domestic violence and has a family law issue or a question, or you think they'd benefit from some early family law advice, please do call us. So there you'll see our website where there's an online referral form that you can just click through, enter your client details with their consent, and we'll contact them directly, phone number, email. I often say that you don't need to be separated to get legal advice. So something that I'm doing as a domestic violence lawyer who specialises in family law is often giving advice to those who are thinking about separating or newly separated. Often there's lots of questions at that time in terms of what's likely to happen to kids, what's likely to happen to the property, things about divorce and AVOs I need to know about. So it's never too early. Talking to a lawyer does not mean you're going to end up in court or that you're starting some kind of adversarial process. It can just be a confidential way to get some early information. So contact details there. Okay, so as I said, our session first section we'll be discussing issues that might be really front of mind before and right at separation. So in a first advice, often I'm kind of dividing my time between talking about children. So that's often one of the most pressing things clients want to know about. So who are they living with? How are they spending time with the other party? Does the client want that to change? Does the other party want that to change? How would the court likely treat these matters? Are there safety concerns? Are there any specific issues that might be in dispute? So name change, medical or schooling issues, relocation issues in terms of where parties are intending to live post-separation. So we'll address those a little bit. Finances, so often I'm kind of giving a guide about how property of the relationship might be split. So in those early advices where you're really just getting information about finances. So property settlement, child support, discussions about any interim arrangements in terms of finances or debt, any pressing issues in relation to finance and debt, kind of need to talk about at that time. And then of course, safety. So often the first priority when someone's newly separating or considering separating is safety. We know that separation is one of the most dangerous times for victims of domestic violence. Studies indicate that leaving a violent partner increases the risk of more severe and even fatal violence. Perpetrators who experience a loss of control at the point of separation may try to regain it through escalating forms of family violence. In some cases, this has amounted to killing victims, including children, as that ultimate act of power and control. So ending an abusive relationship doesn't necessarily end the abuse. As family lawyers, we need to be really acutely aware of that. For some victims, it can make it worse and can be a real flashpoint for escalation. And some women who are killed at separation have never experienced physical violence before. So that was brought into sharp relief for many with the death of Hannah Clark and her children last year, a case that many of us will be familiar with, and many other women who've been killed recently after separation in recent years. So it's really important to prioritise safety when you're giving legal advice at that point. In saying that, lawyers are not DV specialists, even specialist domestic violence lawyers like myself are not DV specialists. So it's part of my job to identify domestic violence, respond to it by ensuring that my client is connected with those specialist services that many of you will work for safety planning and support, and incorporate information about safety risks into my legal work. So for example, I'll be discussing with the client safety and timing in particular. So if we're going to initiate contact with the other side to start a disclosure process, really working with the client around safety, is that going to escalate safety risks? How are we going to manage that? Who's she working with in terms of safety planning around that? So, you know, knowing it's not my job to engage in domestic violence specialist services and safety planning, but knowing that it is my job to ensure that I'm responding to those safety risks appropriately, making sure my client has those appropriate referrals, and not unintentionally encouraging or engaging in those violence supporting narratives. So for example, blaming the victim, minimising violence when it's reported to me in my instructions, or abusive behaviours, and being careful and considerate about the way that I'm giving advice, about the way the courts might take into account certain facts or circumstances and things that we need to think through. So I won't get into that too much. I could probably talk about that all day, but that's an important part of our job. And then obviously when we're dealing with safety, we're giving legal advice about AVO matters. So discussing safety with the client, discussing whether an AVO might be appropriate, discussing whether they've approached the police or want to approach the police to see if the police will apply for an AVO on their behalf. Sometimes talking to them about that, the Section 16 of the Crimes and Domestic and Personal Violence Act. So that's a test for whether there's reasonable grounds to fear and in fact fears DV offence, intimidation or stalking, the test for the AVO. So talking to the client about what behaviours have been present. Do we think that on the basis of the facts, it's likely the court would make an AVO on the balance of probabilities in this matter? Yeah, and talking through approaching the police, what supports are needed for that. If the police are not wanting to take out an AVO, but we think there is still grounds under the Act, then talking to the client about how they can apply themselves for an AVO, what would be involved in that process, how they can be supported. and I won't go into the details of ABOs too much because I know there's another session at the forum in relation to ABOs specifically, but certainly we're talking to our clients about that. And then the last thing that I probably mentioned in relation to safety when we're talking about before and at separation is just victim services support. So flagging that for the client, many of you will already be aware. There's a few different categories of support which might be helpful for a client who's fleeing domestic violence, in particular the immediate needs support package of up to $5,000 for relocation security costs. So seeing whether we need to assist the client in applying for victim services and kind of other supports that might be available. So then once we've spoken about safety, we're then often talking about kids and property. So first we'll deal with property. So there's probably going to be a number of pressing issues for a client when they're newly separated. How do I pay my bills? Who will stay in the home? How do we divide property? And so, as I said, with the initial advice of the client, we're just discussing the most urgent issues and getting them to start thinking about collecting information and documents that's going to help inform them and us, hopefully, about the total picture of what their finances are. So in terms of difficulty paying bills, often I'm referring to a financial counsellor, and I think we're going to hear from a financial counsellor at the forum, about notifying lenders and utility providers, accessing DV and hardship policies where appropriate, accessing material aid, including the new emergency violence payment or victim services, Centrelink advances, crisis payments, discussing whether any debts can be reduced, whether there's any debts the client shouldn't be responsible for, so getting advice about that. And then also discussing the availability of child support. So most of you know when parties separate, there's child support agency. You can lodge an application for child support of children in your care. So all parents in Australia have financial responsibility for any of their children. It's completely separate to what, if any, time they spend with them. It's an independent financial responsibility to be financially responsible for children that you have. And so there's a formula that the child support agency applies to assess how much each parent should be paying in terms of child support. And then there's some different options in terms of collection. So whether it's private collection through the child support agency, there's kind of some different options in relation to that. There is an exemption. And so I should say that Centrelink will often require separating parties to be assessed for child support and lodge a child support application if they're in receipt of Centrelink. So that can be taken into account in their Centrelink assessment. And there is an exemption for people who have experienced domestic and family violence. If they're concerned that lodging that child support application is likely to inflame the situation and put them at risk. So they don't have to, but they can potentially access that exemption where they're not seeking child support. But it's probably a good idea for a client to get legal advice before they're making that decision. So the legal aid child support service is a really good option for legal advice, early legal advice if your client is considering kind of whether they're applying for child support, what type of collection they want to elect, and also if there's issues with child support. So if the other party isn't paying, there's difficulty collecting, if the other party is underreporting their income, or there's other kind of issues in terms of the calculation of collection. So really good free legal advice, legal aid child support service. You can just Google it, and there's a number clients can call and they can get kind of really quick, good legal advice independent about that. The other thing I'm talking about often in relation to that, how am I going to pay my bills, what's the money coming in, is spousal maintenance. So this is in the context of a broader sort of family law property settlement. Spousal maintenance is an entitlement under the Family Law Act for one party to financially maintain the other. And we won't get into it too much, but often the application we're making is in relation to urgent spousal maintenance, so under Section 77 of the Family Law Act. And it's really assessed on the client's need for that money and the other party's ability to pay. So that's essentially the test, and will vary in each case in terms of the applicability of that. But Certainly clients can get some legal advice about whether they might be entitled to a payment of spousal maintenance, particularly if, you know, there's children, they're really under financial hardship and having difficulty in making the sort of payments for the outgoings of the household, in terms of, particularly as it's relevant to the wellbeing of children. And the other party has some capacity to contribute. Really important to get some advice about spousal maintenance, which is in the context, will be kind of considered in the context of the broader property settlement, but it's quite separate. So it's a separate order for spousal maintenance. So get some advice about that. Okay, and then in terms of who will stay in the home, so often we're having conversations around if the client is renting, is there an ABO that excludes the perpetrator? If not, does the client want to go? Does the client want to stay? If they want to stay, what are the options for having the other party removed off the lease? So often referring for tenancy advice in relation to that, or if the client wants to go, making sure that they're lodging that DV termination notice, so that once they've left the property, fled as a result of domestic violence, they're not incurring liability for rent in arrears, damage to the property, things like that after they've left. So if they own the property, then we're having a conversation about kind of what's going to happen in the short term and what's going to happen in the long term. So in the long term, we need to talk about it in the context of a property, family law property split, in terms of what other property is there, what's likely to happen to the home, is it going to be sold, is one party going to buy the other party out. In the interim, we're talking about what's going to kind of happen between now and when we reach a final agreement. And so again, an ABO might be appropriate. And if not, most parties do reach an agreement about who will stay in the home and who will go. And often the agreement is the person that stays in the home continues to be responsible for the outgoings, but that's not always the case. And certainly if you're staying in the home but you're having difficulty meeting, say, the mortgage repayments, well, one, there's you can investigate hardship options with a financial counsellor to reduce kind of payments in the short term. And then two, there's also the potential for interim family law orders in relation to who pays the mortgage and contributions to the kind of outgoings in the interim. And another type of sort of injunctive relief or interim order might be an order for sole use and occupancy of the home. So that's where the parties can't agree who stays. There isn't an ABO in place that determines that. So under Section 114 of the Family Law Act, there is the potential to apply for injunctive relief that gives one person sole use and occupancy of the home. So the onus is on the applicant in those cases to apply for that interim order and convince the court that it's not reasonable for both parties to continue to live under the same roof. And they look at a number of factors, but in particular kind of needs of children, conduct of parties. So good idea to get some legal advice about that if there is that dispute around one person remaining in the home. And then finally, in relation to kind of that early advice for property, we're talking about how the property is likely to be divided. So when first speaking to a client, like I said, I really want to get that full picture of their and their ex-partner's finances. So value all assets in joint or sole names, whether they're accumulated before the relationship, during or after. Want to know about them all. Any debts, again, in joint or sole names, really important, all likely to form part of the property pool, or at least there've been argument about whether it's in the property pool or not, so we need to know, really expansive in terms of all of that. And so we're trying to get as much of that with the client as possible. Where the client can't get access to some of that information, then we can look at what the other options are. But where they can get that information simply makes life much easier in terms of getting advice about property. And then we're generally getting instructions that are going to give the family lawyer enough information to give some general advice around what the kind of likely split the court might look at in this matter is, to kind of inform the client's thinking in relation to, does the house need to be sold? What's kind of likely to happen? How do I start planning? So that would be, you know, the duration of the relationship, is it de facto, or were they married? Are they divorced? Because that gives us some information about one, limitation date. So do they need to quickly file an application for a property settlement, because actually they've been divorced for almost 12 months, and so they're almost out of time, or they're de facto and they've almost been separated for 2 years, so they're almost out of time, or do they have some time? And then also just kind of making sure that they fall into that category of de facto relationship that is entitled to a property settlement and likely to be. And then we're looking at total pool, what's there. So that includes superannuation. So just because there's only superannuation, say in the other party's name, potentially in the husband's name, that can be split as part of a property pool split. So even if it's only superannuation, it still may be worth the client pursuing in terms of a property split, or at least getting some information and legal advice about. And then looking at contributions of the parties is the next step. So we'll look at kind of the not financial and non-financial contributions of the parties throughout the relationship. Then we're kind of looking at the future needs of parties. So obviously in particular children, who's working, who's not, any disability, and making adjustments on the basis of those instructions, and then kind of giving the client an indication of what the court might likely do in their matter, the kind of range or ballpark of percentage adjustment that they might expect in terms of the total pool, and what that would look like in terms of the assets retained or not, and that gives them some ability to kind of do some planning. Okay, so then in relation to kind of before and after separation for children's matters, this is where we're talking about the process for reaching agreement. So most matters do not go to court. The vast majority of matters will reach agreement. So that's either just a kind of informal agreement between the parties, or it might be through a mediation, and it might be a written agreement, like a parenting plan, and then in some cases a consent order as well. So an agreement that's filed with the court, asking the court to turn that into a formal court order by consent. So when I'm talking to clients at this stage, often they are thinking about entering negotiations with the other party, maybe through a mediation or maybe just having discussions, and they kind of want to get a sense of, well, what would the court likely do? Sometimes when you're dealing with kind of an violent or abusive other party, they are making threats. So it might be things like, I'm going to take the kids, you're never going to see them again, you're a terrible mother, the kids are going to live with me. Just sort of, oh, I'm going to take them overseas, or things like that. And so often the client really wants to kind of reality test these things that they're hearing from the perpetrator or the other party around, is this realistic? Can he do this? What would the court likely do if this matter ended up before them? And so that's when we're talking about these kind of main sections of the Family Law Act. So we've got them there, you don't need to know them, but these are the sections that I'm usually talking to the clients about in these matters. So firstly, that the court is going to make any order in relation to children in the best interest of the child. So the best interest of the child is the paramount consideration. So that's what the court has to look at. And in deciding what's in the best interest of the child, there's really two main things the court needs to look at. So meaningful relationship with both of the children's parents, and need to protect the child from harm. So it's really those two primary considerations. So the Section 60C primary considerations that the court's looking at when they're deciding what is in the child's best interest in terms of what orders will they make. And protect, so meaningful relationship with both parents, protecting the child from harm, and the need to protect the child from harm trumps the meaningful relationship where that's relevant. So where there's safety concerns, that needs to be prioritised by the court over the meaningful relationship. And then there's a whole range, I think 14 or something close to that, additional considerations also set out below that the court can also take into account, but given less weight than the primary considerations. So they are things like the views of the child, depending on the age and maturity of the child, the nature of the relationships between the parents and the child, the capacity of the parents, if the child's Aboriginal, the right of the child to enjoy their culture. So a range of kind of other considerations that the court also can take into account. And then we're sometimes talking about, so that's most commonly the things that the court are looking at to determine what's in the best interest of the child. And mostly that's for all parenting applications, but Most commonly, you're looking at who the child lives with and how they're spending time with the other party. That's the most common kind of thing to be decided with those considerations in mind. And then the other thing that we're talking about is in relation to parental responsibility. So parental responsibility is in relation to the long-term decision-making about children. And so that is not the kind of, that's not necessarily where they live, who they live with, and it's not necessarily the kind of day-to-day decision-making, but that's things that are likely to have really kind of long-term impacts. So religious, medical, schooling, where they live in terms of if it's relocation, so, far away from the other parent or, significant difference from the other parent. So those kind of parental responsibility decision-making. And so the Act has something to say about that. So it says that there's a presumption that the child's parents will have equal shared parental responsibility. So that means that there's a presumption the parents will share the long-term decision-making for children. That doesn't necessarily equate to equal time, so they're separate, but there's this presumption for equal shared parental responsibility. And so family violence is one of the conditions. So there's a range of conditions where that presumption can be rebutted or offset, and family violence is one of those. So where there's family violence, the court may determine that it may not be appropriate for there to be equal shared parental responsibility, but it's from the starting point of the presumption that there will be. And then the two other big things that I'm often talking to clients about in terms of kids matters when they're newly separated is relocation matters and recovery order matters. So relocation matters just is sort of like a colloquial term for where parents are considering taking the children and relocating and living in a different location to where they currently live. So these are dealt with under the Act as just parenting matters. So the same best interest principles apply in terms of deciding whether the children whether there should be orders to allow the children to relocate. And so if the client is considering relocating, it's really important they get some legal advice about that. So get them in to give me a call or talk to legal aid, get some legal advice in relation to relocation and considering their options, what the court would likely do in their matter if it was to end up in court. Really, important to get some legal advice in relation to relocation, because sometimes the other thing I'm talking to clients about is recovery order matters. And recovery order matters are dealt with under Section 67U, which is that the court can make a recovery order, which basically means the court can kind of recover a child, bring them back to where they were. So it may be that if one party flees, say there's no housing availability in the area and they go to a new location with the children, the other party may file an urgent application in family law courts for recovery of children, which would mean that they'd be asking the court to make a decision that the children be returned. And so those applications are dealt with often on short notice, so urgently. And it can be a real kind of shock and not a nice way to commence family law proceedings if you're being brought before the court on a recovery order application to bring the children back. Similarly, I'm sometimes talking to clients about whether they need to make a recovery order application. So often clients have questions around what happens if the other party just picks the kids up from school and takes off with them. And so that may not have happened, but they've got concerns the other party might have threatened to do that before, and they've got concerns about that. And so AVOs can provide some protection in relation to that where they apply to children particularly. But where there's an AVO, no AVO, or potentially the children aren't listed, and the other party just picks up the kids and takes off with them, potentially is talking to the client about making a recovery order, so urgent application to the family law courts that children be returned. And if you're making that application, the court is going to look at what's in the best interest of the child. So it's it's Section 67B kind of still says that the court needs to look at what's in the best interest of the child. So if that's the case, often what I'm talking to clients about in those circumstances is the process. So, okay, if this was to happen, the other party was to take off, what would be the process in terms of us filing an urgent application, to the family law courts? How quickly would it be listed? What would the court take into consideration? How would that work in terms of the federal police actually executing a recovery order application, and kind of the logistics of it as well. So, so it can be a really good idea to get some, if that's something that's concerning your client, to get some legal advice about it, and talk about the process that would be involved, and make sure they have those kind of contacts and information if that's a concern. And then also on the other side, if they're thinking about relocating and don't have consent from the other party, just getting some advice about recovery order applications and whether, what their prospects would be, whether that seems likely in their case and what their prospects would be if that was to occur. Okay. So the second stage where I'm often, where you might be assisting clients and where I'm often giving advice in navigating the family law system is when they're trying to reach agreement. So it's another really important juncture and a good idea to get legal advice. And so as we spoke about, most parties don't need to go to court. Vast majority of people agree. Different types of agreement kind of available. So it might be an informal verbal agreement. It might be a written agreement, sometimes with help from a third party or a mediator. It might be a more formal written agreement. So that might include a parenting plan that they have agreed with the help of a mediator and signed and dated at a mediation, or through a lawyer with help with lawyers, or a binding financial agreement if they've had, if they've both had independent legal advice. So that's in relation to property. We won't get too much into that. Or the one type of agreement would be consent orders. So orders, court orders, but by consent. And so when the clients are at this stage, I'm often talking to them about if they have safety concerns, making sure they're raising those with mediation, how to find a mediation service. So there's a great link there I put in the slides to find the mediation service near them, and how a lawyer might be able to assist them in terms of giving some advice before the mediation or after the mediation, and also the options in terms of legally assisted mediation. So that's where it's still a mediation. It's not kind of a litigation process or a court process, but both parties have lawyers there at the mediation to assist them to try and come up with proposals and reach an agreement. And so the most common way people access legally assisted mediation is through a grant of legal aid. So if they're eligible for a grant of legal aid, and so there's a link there where they can have a look. And they can get assessed around whether they'd be eligible for a grant of legal aid to engage in legally assisted mediation. And so really at this stage, I'm really wanting to talk to the client about, well, what are the kind of proposals? So what's happening with the kids now? Where are they living and how they spend time with the other party? Or are they spending time with the other party? What do you want to happen? What do you think is going to be in the children's best interest in terms of where they're living and how they're spending time with the other party? And what do you think the other party wants or thinks in relation to what's going to be in the children's best interest? So looking at those different proposals, what's the gap between them? So how close are we in terms of agreement, or how far away? Is it that there's really serious safety concerns? So actually, we don't think that their children will be safe spending time with the other party at all, or would only be safe in really limited circumstances. Does the other party, both the parties want the children to live with them? So this is kind of really significant gap between their proposals. So you're kind of having that, trying to get them to flesh out kind of what they want, what they think the other party wants, what's the kind of room between them, what room is there to move, and what room isn't there to move. And then also so that's kind of the main thing that we want to think about. And then there's a range of other things we can give kind of prompts and ideas in relation to in terms of special days, Christmases, holidays, birthdays, how are you going to spend those? What about phone contact? What about school holidays? All those different things that might be covered off in a parenting plan or agreement that they might want to think about now so they can reach agreement with the other party. So family lawyers can be good just for thinking about, have you thought about this? Do you want to say anything about who takes the children to the doctor? What notification you get about schooling events or medical events, or how those happen? What happens with extracurricular activities? So kind of thinking through all of that stuff. And in a mediation process, there is a lot more scope. It's less rigid than a litigation process or a court process, if you like. So there's a lot more scope to bring up things that might seem like little things, but actually you think they're really important to the children and to their life going forward. And so you might be able to include those things in mediation, in a parenting plan. Okay. So we won't go into property reaching agreement in depth, but basically it's kind of the process we spoke about before in terms of working out what the client's likely entitlement or offer of settlement would be, kind of range of likely possibilities in terms of the split. But things that I want the client to be thinking around is disclosure. So do they have all the information they need in relation to the finances? Are they concerned the other party's hiding anything? If so, what? How can we get that information? Getting legal advice about what considerations the court would likely take into account, and so making sure that their offer to settle is sort of broadly in the ballpark of what the court would likely do. Really ensuring that the agreement is enforceable. So if the client is agreeing to sort of an informal property split in terms of they just agree they're going to sell the house and split it 50-50 or something, there's nothing in writing. One, making sure that they're fully informed about kind of what they're potentially giving up in terms of entitlement before they agree to that. And it's, you know, fine if they do want to just go through that informal process, but at least they have the information. And two, just making sure anything that they're agreeing between themselves or in writing, writing is a different thing, but anything they're agreeing between themselves is enforceable. So a really good example is when the parties agree, okay, you're going to be responsible for the joint personal loan. So you're going to make those payments going forward. That's going to be your responsibility and I'm not going to be responsible for that. So that's good that they've agreed that. But the problem with that is that that doesn't bind the third party. And even if you get that in a binding financial agreement or even sometimes as an order in consent orders, that won't necessarily be binding to the third party. So that will mean if the loan is jointly severally liable for both parties, just because one party's agreed to be responsible for it, if they fail to pay it on time, for example, if their circumstances change or they just sort of stop paying, the bank or the lender can still often pursue our client, the other party, even though there's an agreement that the other party pay. It doesn't kind of alter the bank's ability to recover. So you're really wanting to make sure you're actually addressing those and not signing up to or agreeing to arrangements where, yep, you're responsible for the joint personal loan, you make those payments, but that's not an enforceable arrangement and your client and our client still remains liable. So that's something we really want to be sure about, especially where there's been family violence and in particular financial abuse in the past, because those joint loans and things like that can be used as an avenue to further the abuse. So we really want to make sure those things are tied off whenever possible. So really good idea to get legal advice about those kind of things. So binding those third parties. And then, as I said, make sure you get advice, even if it's just super, potentially have an entitlement. It can be really handy for women in particular later in life. So you don't want to just forego superannuation that's not in client's name. And then finally, I just want to mention here, so there is legal aid available for small property pool matters. So basically where there's less than $500,000 to split, there's a pilot on at the moment for legal aid. So encourage clients who need some legal advice about that they can contact us, but they can also contact legal aid for access to kind of legally aided mediation and then potentially a lawyer for litigation as well. So when we're in the reaching agreement stage for kids, pretty common questions are, what is a parenting plan? What if the other party doesn't follow it? How does it work with an ABO? And what happens if we don't reach agreement? So parenting plan is not a court order. It's not legally binding in the same way a court order is, or it's not legally binding, but it has some recognition under the Family Law Act as a document that you can hand up to the court to indicate at this point in time, this was our intention, our agreement was this, we reached this parenting plan, and the court can have a look at that. Also, you can provide it to police, schools, other parties as evidence of the agreement that you've reached, but it's not binding. So if you breach a parenting plan, in a sense, sort of next question, it's not like a breach of court orders. There aren't the same penalties attached to it. So if you've entered into a parenting plan, but then one party just stops following it, really probably need to get legal advice. It would depend on what the kind of breach is. Has the other party just taken off with the kids, or is it just that they're not showing up for their scheduled time? If that's the case, then you really, you want to talk to a lawyer about what are my options. Do I try and go back to mediation to see if we can reach an agreement? Do I just, is the ball in the other party's court, like they have the ability to access this time, but they're just not taking it up? So it really would depend on the circumstances, but it doesn't have the same ramifications as court order. It can be altered later, but later agreements. Court order can actually be altered later by later parenting plans, but how does it work with an AVO? So I think there's another session at forum on AVOs and this particular thing, and most of you will know there's kind of a standard order 6 for AVOs that allows for contact in accordance with a written agreement about children through a lawyer or a mediator. So that means AVO and a parenting plan can work alongside each other. So the AVO can still be in place. If the other party becomes abusive or breaches that AVO in any way, they can still be charged, but they are allowed to do things under the parenting plan without being in breach of the AVO necessarily. So they kind of work together. And then what happens if you can't reach agreement in mediation? Well, you'll be both, if you attempt mediation but it's unsuccessful, you both likely be issued with a Section 60I certificate saying you tried mediation but couldn't reach agreement. And you can use that Section 60I certificate to make either of you can make an application to court at a later stage if you choose to do that. So we'll talk a little bit more about that when we get down into the court section. Okay, so family law court litigation, very stressful, extremely upsetting for clients. Deciding where children will live and how they'll spend time with the other party has really significant ramifications for people's lives and well-being, and especially where safety and family violence is an issue. So a really good idea to try and get clients psychological support or emotional support during this time, in addition to obviously legal advice. So most of you will know, as at the 1st of September, the family law courts were combined and became the Federal Circuit and Family Law Court of Australia. So the features of the new court are a greater focus on cost disclosures and expectations around compliance with court orders. So one of the kind of principles is that people were spending too long in the court system, spending too much money on legal fees, and that is there wasn't a great enough focus on compliance when there was court orders, and then also with mediation and trying to reach agreement, and lawyers having a better focus on reaching agreement. There's specialist court lists now, like the COVID list, the contravention list, so a range of kind of different specialist lists, and a greater focus on dispute resolution, including mediation that occurs at court and is managed by the family law court once you have litigation on foot. And at the same time, we've got new court rules, and they have a strong focus on, again, resolving matters, greater use of registrars judicial registrars to triage matters and run earlier mentions and directions hearings. So you'll see there on the slide the kind of new pathway. So it's expected now that cases will follow this. So there'll be a first court event, and at the first court event is a real focus on figuring out what are the issues in dispute, what information does the court need in order to settle them, is there any prospect of the matter resolving, what's needed to help this matter resolve, what attempts have been made to resolve it, and if there haven't been sufficient attempts to resolve it, so the parties haven't really tried, then sending the parties off to do that. Then an interim hearing if required, dispute resolution, so that court-based mediation we were talking about, a compliance hearing, a trial management hearing, which means checking that everything's ready to go for the trial to go ahead, and a final hearing. And the idea is you have that compliance hearing within 6 months and the final hearing within 12. So shortening the time people are in the system for. And so these are some of the kind of the main sort of features in terms of features of the family law system that you might be familiar with, and also professionals that are involved. So I just want to give you kind of a rundown on those. So when you're hearing those from your clients, you kind of have a context for them. And I guess it's probably worth us talking a little bit just in terms of risk identification as well. So the family law courts, especially we're mostly talking about children now, take family violence into account when they're making decisions about the best interests of the children. So you remember that primary considerations, they need to protect the child from harm in decisions that they make. And then in terms of safe, so that's how it's taken into account at a legislative level. Obviously, you know, I think there's probably improvements that can still be made in terms of how family violence is taken into account in the decisions that the court makes. And in particular, something that I've written about before is ensuring the courts make an early decision in relation to findings about what family violence occurred and letting that inform the rest of the decisions that they make. But there's been, in particular, some moves for the court around management of family violence in kind of at court and in a case management sense. So earlier risk identification. There's a project called the Lighthouse Project, which really focuses on that. Unfortunately, it's not available here. It's available in Parramatta and Brisbane and Adelaide registries. The ban on cross-examination we spoke about, and then the EVIT list, again, not available here, but that's a specialist list for high-risk matters. And so there is work going on in terms of how family violence is managed in the family law courts. But moving on to these kind of really common aspects of family law case. So most of you will have heard of an independent children's lawyer. So it's a lawyer appointed by the court to represent the child's best interests. So it's not direct representation of the child. It is a counsel assisting type model in that the ICL forms an independent view about what's in the child's best interest and presents that view to the court, and they're responsible for kind of collecting evidence in relation to that and presenting it to the courts. They might meet with children that are school aged. In fact, they should, but they don't always. And they'll, you know, speak to counsellors, school teachers, gather documents, and try and collect evidence around what's in the best interest of the child. In relation to subpoenas are really commonly issued in family law proceedings. Parties are usually at liberty to issue up to 5 without leave of the court. Usually they're for production of documents, so things like police records and medical records. Subpoena production can be objected to by either the other party, so in relation to whose records they relate to, or the person who's being subpoenaed. So that might be the counsellor or the doctor. And so generally speaking, where there's an objection to production, the court's going to weigh the probative value of the material. So does it provide important information about the best interest of the child versus the potential harm of producing the material? So would it breach confidentiality? Would it damage the therapeutic relationship? Is it likely to reveal confidential information which might put the victim of violence at risk? So they're the kind of concerns that the court is weighing. But in general, subpoena powers are quite broad, and the court is looking to bring in evidence that is relevant in terms of them determining what's in the child's best interests. And then finally, courts children's services. So this is sort of a rebrand of existing services that occurred before the merger. So it's basically staffed by psychologists and social workers who work for the court, and they prepare reports for the court regarding issues in dispute in the child and their best interests. So the main kind of 3 reports that are produced are a child impact report, a specific issues report, or a family report. And they usually involve interviews with the parents and the psychologist, and also observations for the child and the parties, and then reviewing the other information available and producing a report and recommendations often to the court. So if your client has questions in relation to, so they're 3 big kind of aspects of the family law system that often do sort of produce concerns and questions for clients, a really good idea for them to get legal advice in relation to that. And those things could probably talk about all three of those for an hour each, but we don't have time today, so I just want to give you a brief overview. Okay, and that's it from me. So yeah, I suppose the big takeaway is really important to get individual advice at each of those proceedings, stages of proceedings. Hopefully that's given you a bit of an overview in terms of the types of issues and stages of different parts of the family law system and stages of the matter that your clients might be negotiating and navigating, and help you to support them through that. And yeah, my contact details are there. Please do contact me and don't hesitate to refer your clients for advice.